Hey everyone, this is Layla Shaver from My RIA Lawyer, and today I'm talking to you about the 8 things you need to know if you have been named in a FINRA arbitration. The number one thing you need to know if you have been named in a FINRA arbitration is get an attorney. I don't care if your broker dealer or your RIA has told you they will represent you. It is always best to get your own counsel. Speaking as someone who used to be in-house for a broker dealer, there are times when your interests are going to separate from those of the firm. And you want to make sure you have your own attorney who is always, and consistently representing you and your interest, even if they're consistent with your firms and when they aren't. So make sure the first thing you do is get counsel. The second thing you should know, you should always get a professional to draft your answer to the statement of claim. I can't tell you how many advisors come to me having responded themselves to a statement of claim, and they didn't put the remedies they should have asked for. They didn't request expungement. They didn't put forth their story. They just denied. Your answer to the statement of claim is the panel's first introduction to you and what your side of the story is. So make sure you are getting a professional who's preparing that answer to the statement of claim. You want to put your best foot forward with the panel. The third thing you should know if you've been named in an arbitration, not only do you want to get a professional to draft your answer, you want to make sure that you are requesting an award of expungement. With the recent proposed changes to the expungement rules, this may be one of your only opportunities to get this customer complaint off of your U4. So make sure you are requesting that expungement in your answer. The fourth thing you should know is that FINRA posts online through the FINRA website the exact things that you can expect during the FINRA arbitration process. And you should absolutely get familiar with that process and what you are expected to present during the discovery process. Yes, there are lists of what the other side can ask for from you. So make sure you're familiarizing yourself with the documentation and information that FINRA says you have to provide during the course of arbitration and that the other side is entitled to ask you for. So get familiar with the process. Don't dig a hole and stick your head in it. Understand what you're going to be dealing with. The fifth thing you should know if you've been named in a FINRA arbitration is that 90 to 95% of these cases actually settle, especially where you are still employed with your broker-dealer or RIA. You want to make sure that you are given an opportunity to review any settlement document, whether it's drafted by the other side or your employer. You want to review that. You want to know if you're part of the settlement, how much the settlement is for, if there's any admission of wrongdoing, and whether there's an agreement to allow your expungement to move forward. These are things you want to be aware of. I can't tell you how many advisors I talked to, they were never involved in the settlement process. They don't know what it was settled for. They don't know if there was any wrongdoing that the firm said they did. They have no idea. If you are named as a party in an arbitration, you need to know what's going on if there's a settlement. So make sure you're involved in those discussions. And going back to the number one reason of getting counsel, this is where your counsel will be stepping in and making sure you have a voice in those settlement discussions. The sixth thing you should know if you've been named in a FINRA arbitration is that FINRA arbitration is going to be disclosed on your Form U4. But fear not, you have an opportunity to add some of your own side of the story under the broker's comments of the disclosure. So make sure you're taking advantage of that and putting a few sentences about your involvement and about the client. If someone is looking at it, whether it's a prospective employer, client, or prospective client, they're going to get some information about your side of the story when they see that disclosure in your Form U4. So make sure you take advantage. It's the broker's comments. The seventh thing you should know if you've been named in a FINRA arbitration is that FINRA awards are final. There are very limited and very nearly impossible ways to get a FINRA arbitration overturned, but essentially they are final. So you want to make sure you're taking this process seriously. You want to make sure you're engaging that counsel, and you want to be an active participant in the process. Don't dig that hole and stick your head in it. Know what's happening. This is very serious, and this is something that's going to be disclosed on your Form U4. So make sure you are active in that process because those awards are final. The eighth and final thing you should know if you've been named in a FINRA arbitration is that these things take time. If you end up settling the matter, you could look at as soon as 6 to 8 months in concluding it. If you end up going to hearing, you're looking at more 12 to 15 months. The point is, this is a marathon, not a sprint. Make sure you're emotionally, psychologically, and physically prepared for it. It can be a lot to deal with the challenges of opposing counsel, disclosing information and documentation, being pestered by your employer. It can be a lot. But stay engaged, get counsel, and you'll get to the end. And if you follow these tips, you may be able to get it expunged from your record. FINRA arbitration can be a lot. And these are definitely the 8 things you should know if you've been named in a FINRA arbitration. A word of caution: do not go it alone. Make sure you have counsel. Make sure you have someone representing you and your interests and who's advocating for your side of the story. And if you're looking for that kind of counsel, give us a call, 770-462-2118. We'll get you in front of an attorney today because we know the clock is running.